the inaugural edition of The Opinion, the talk show where your opinions matter. I am Mirna Santiago.
And I'm Adeline Ortiz, and we're your hosts.
Today our topic is affirmative action. And joining us for this discussion is civil rights attorney Lee Nuwesra, who concentrates in labor and employment law.
Hello. Nice to be here.
Welcome.
Before we delve into our opinions today on affirmative action, a brief background may be in order for those people out there who are not familiar with affirmative action. What do you think, Adeline?
Absolutely. Basically, the first time that the phrase affirmative action appeared was in a 1961 executive order by President Kennedy, wherein he ordered federal contractors to take affirmative action to hire more blacks and to treat them fairly. This executive order was later expanded by President Johnson, who extended it to also benefit women. However, the legislature didn't take any action on this issue until the Civil Rights Act of 1964, where it specifically prohibited discrimination based on race and other classes. Significantly, the legislature also created the Equal Employment Opportunity Commission, which is an administrative agency designed to handle discrimination type cases. Despite the fact that the act has been around for nearly 50 years, it continues to be heavily debated. In fact, isn't there something pending in the U.S. Supreme Court right now?
Actually, there is. This fall, the Supreme Court is going to hear an affirmative action case. And in that case, Abigail Fisher, a white woman, is claiming that the University of Texas denied her admission into the university so that a less qualified person of color could gain entry. Now, the last time that the Supreme Court addressed affirmative action was only in 2003. And in that case, Justice Sandra Day O'Connor actually mentioned something to the effect that she didn't expect the court to hear another affirmative action decision for 25 years. Well, apparently Sandra Day O'Connor was wrong, because they're hearing it again less than 10 years later. And it is that fact that has some people saying that this is going to be the end of affirmative action. Now, add to that the fact that Chief Justice Roberts has gone on record in other Supreme Court decisions, one as recent as 2007, saying that governmental entities should not consider race with respect to government programs. And Justice Alito, who is a self-described conservative, and he was appointed to the court by President Bush, has agreed with him in those cases, as has Clarence Thomas, another conservative, and they will be hearing this case as well. But there are two Obama appointees on the court currently. There's Justice Kagan, who some people have used the L word to describe, and you can get your minds out of the gutter, people. I'm talking about liberal. But she has had to recuse herself because she was on the case when she was a Solicitor General under Obama. And we also have Justice Sonia Sotomayor, and she's, you know, the sole moderate, if you will, progressive left to try to stem the tide against affirmative action in the Supreme Court. And most people, myself included, don't think she's going to do that because she's a woman and a Latina, and she doesn't want to be seen as pandering to the affirmative action interest, if you will. But, you know, I have to say that, you know, people are prognosticating this is the end of affirmative action. And if it is the end of affirmative action, then I will have to say good riddance and may it rest in peace.
Wow.
If I may just jump in, specifically with regard to Justice Sotomayor, I can tell you, having appeared before her both at the district court level as well as the second Court of Appeals level, that she will do whatever she thinks is right and appropriate, regardless of what the public perception might be with regard to that. And just a little note about that, as you know, Justice O'Connor, and I agreed with her when she thought that it might take about 28 to 30 years before we don't have to worry about it. And I equate that, for example, to the fact that when it came to sex, currently, as I understand it, there are more women going to higher education, in higher education at universities, than there are males. And that was as a result of the 1964 Civil Rights Act that Adeline had alluded to earlier, And if you really look at it, when the numbers start balancing out, as far as the sex protected class, it was within 30 years after the act was enacted. And just one last note, if I may, with regard to the Grutter case is what you're referring to.
Yes, in 2003.
Actually, that case did not say that states must abide by affirmative action.
It was permissive.
It's permissive. As a matter of fact, as you know, there are 2 states that actually prohibit that.
I think there's more.
That I'm aware of. One is Michigan and the other one is California. And that's why you get less and less minority background students going to universities in those 2 states.
Well, you know, I think I don't disagree with what you're saying, but I think my point was, and you know, if you will allow me to finish what my original point was about the fact that, you know, good riddance to affirmative action, at least in the higher education setting. But before we get into that specifically, I think affirmative action has become so watered down over the years that now it's practically become useless. I think when it was first passed in 1961, Adeline, and you alluded to that, it was designed to protect blacks and blacks only. And it wasn't meant to be a handout. It was meant to be an equalizer because of the institutionalized racism in this country for so many years in the forms of slavery, in the form of segregation, in the form of Jim Crow. But what happened since 1965 when we passed the first affirmative action statutes, right, in the executive order and then the statute that followed? The states and the federal government have now granted protections and concessions to pretty much everybody. We now protect, you know, and give concessions to blacks, to Latinos, to ethnic minorities, to women, to the disabled, to the aged, to LGBT people. In fact, the only people who don't get any concessions, who don't get any protections under the law, are white males between the ages of 18 and 49. So how is that fair?
Well, you talk about fairness, Mirna. These protections are in place because they need to be. And in fact, just in 2008, the EEOC settled a huge case with Lockheed Martin where the petitioner received $2.5 million from the company after the EEOC determined that the petitioner had been subjected to persistent verbal abuse by his colleagues on a daily basis, including comments like, "We should do with the blacks what Hitler did with the Jews, and this country would be a much better place if the South had won." This is 21st century America. No one should be subjected to that kind of abuse in the workplace. It's horrifying that it still exists. You talk about fairness. Well, what's fair? Point out one minority in the Founding Fathers, okay? If you can tell me which one of the Founding Fathers was a minority, maybe we can start a discussion about what's fair, because these are the guys who, after all, wrote our U.S. Constitution. And how is it that that goes again? We, the people of the United States, in order to form a more perfect union, establish justice. But how did they establish justice? Just take a look at Article 1, Section 9, that specifically says, by permitting the importation and migration of such persons as the states now existing deem proper to admit, but that will pay $10 per person. Okay, to be clear, slavery was not just acceptable in the United States, it was big business. It was big business for America for the next 100 years. And the Civil War may have ended slavery, okay, but the legislature took no action for yet nearly another 100 years until it passed the 1964 Civil Rights Act. And here it is, not even 50 years old, and it continues to be attacked.
Well, Lee, I'm curious to know whether, you know, how that has played out in your practice in terms of labor and employment, because, you know, I understand Adeline's point about slavery and how it was big business in this country, but in my opinion, that was in the past and it's time to move on. So tell me how it plays out in your practice.
Well, I'm glad you asked that question. Although the case that is before the Supreme Court currently in Fischer deals with higher education, it may have a rippling effect on the private university institutions that are receiving funds under Title VI of the Civil Rights Act from the government, and they may be cited by cases where I represent minority people, such as blacks and Latinos, whereby the attorneys for the employers would say, well, you know, the Supreme Court said that we should not do that, that we should make a stop to, that. I think it's very important that affirmative action continue to be viable and allowable. Take, for example, the firefighters case that is making a lot of big headlines in the city of New York because it involves New York City, but that can also be felt eventually in the suburbs, such as our local community. The district court judge, whose decision has been appealed by the city of New York, decided that the minority candidates, about 2,200 of them, have not been given the proper consideration to become firefighters and serve their communities. For example, there are over 8 million people that live in the city of New York, and more than 50% of them define or think of themselves as minority citizens. However, in the fire department of the city of New York, only 9% of those firefighters that are either blacks or Latinos. So I think the short answer to your question is that this case that is before the Supreme Court will have that rippling effects and will be down-spiraled down to the average person who works in our communities.
You know, I have to tell you, I don't disagree with what either of you are saying, but what I'm saying is that in terms of the higher education setting, which is where this Supreme Court case is coming from, I think there needs to be a better system than one that is based on physical characteristics. I think that in the higher education setting, at least, we need to be able to create a system that helps those kids get into college that are disadvantaged and underprivileged, as opposed to just because they're women or they're black or they're Hispanic or they're from some sort of ethnic minority. The fact of the matter is that in this country, and if you guys are honest, you will admit that whenever there is a person of color who is at the top of the food chain, if there's a person of color with the position of power, the first thing that goes through people's minds is he or she must have gotten there through affirmative action. In fact, I have personally heard it said about President Barack Obama. People have said President Barack Obama is the first affirmative action president. Okay, seriously? The man went to Harvard Law School, which is arguably the best law school in the country. He graduated at the top 10% of his class. He was the head of law review, and somehow he ends up in the same sentence as affirmative action, for real. And I think the reason that has happened is that that is the perception. The perception is that there is a subset of people, there's a subclass of people in this country. There are the people who have gotten to the top on their own merits, and then there are those that have gotten there through affirmative action. I say let's get rid of the whole system that's based on those physical characteristics, at least in the higher education setting, and create one that's based on something that provides an opportunity for a higher education for every child who is disadvantaged and underprivileged, regardless of color.
Mirna, I really don't think that race or gender are the only factors being considered when it comes to opportunities in employment or in higher education. In fact, I think that colorblind policies truly only continue to disadvantage minorities, okay? Because these are opportunities that have been available to white Americans always, the educational advantages. So really, until the inequities in the system are corrected, so to speak, then racial minorities only continue to be disadvantaged. That you're really perpetuating the racial prejudice that has always existed while continuing to provide the same opportunities to white Americans that they've always had.
Just if I may just say one or two things again here. In your own statement, you concede that Barack Obama, while at Harvard and before that at Columbia, was one of the top 10% of his class. Yes. Guess what? Had Miss Fisher been one of the top 10% of her high school class, she would have been automatically allowed into the University of Texas, but she was not. And my take on when people say that our president, Barack Obama, is the first or the only affirmative action president that we have. My reading of it is, and that's another reason why we should promote affirmative action, my reading of it is that he's the only president who had, based on the privilege of the affirmative action, who was able to become president, which is everybody's aspiration as far as I'm concerned. With regard to the diversity in education, higher education, let's not lose sight of the fact and the reason that they are being promoted is because it makes more enlightened sense to have people of different backgrounds when they are discussing certain topics at the higher education level.
And I would agree with that, but again, you can have diversity without it being based on certain characteristics. There are universities, for example, who promote diversity by having students come in, let's say, from other countries. You can have white students from England and they would have diversity of thought to students who are here in the United States simply by the fact that they grew up in another part of the world. So you can promote diversity without having the main criteria, the main characteristics, be physical characteristics, which is what I see is wrong with the affirmative action programs that we have currently, at least with reference to higher education. I think we can take up a whole other show to talk about diversity in the workplace. I think that's something that's completely different and that I agree with, especially in the firefighter setting that you were saying. It makes sense that if you have a population that's comprised of 30% minorities, why aren't your firefighters 30% minorities? But in the higher education setting, I think it's slightly different, which is what I'm saying, that we should give that opportunity to poor white kids as well, to have that chance to go to get a higher education, especially since poverty is it's rising in this country. And we know the only way out of poverty is by getting an education.
Well, Mirna, I really think that your argument is somewhat misguided. I really think that it sounds like your argument is based on a presumption that the minority candidates are less qualified than their white counterparts. And it is a point that I think that I can appreciate. I don't think that Americans are opposed to affirmative action programs. I think that Americans are opposed to quotas and set-asides, and having unqualified minority candidates displace white candidates for the same opportunities.
Exactly.
Okay? And I can tell you that in my own professional experience, I once worked for a Hispanic woman who managed a team of 13 people. Okay, and yet she lacked all of the academic credentials of any member of her team. She didn't have any of the licenses that were required by all of the members of her team. She spoke improper grammar and vocabulary and terminology in all of her communications and during team meetings, and it was pretty easy to believe that this person was nothing more than a token minority, or basically someone who the company had hired or promoted to give the illusion of diversity. Okay, so that they can get a smiley face on their diversity reports, when in fact, for all purposes, this person did not appear to be qualified at all to hold the position that she was holding. I think that that is what Americans can't stand. I think that when they see something like this, this is what they think of as affirmative action. But I think that it's important to distinguish between what affirmative action programs are and what they are not. Essentially, race is not the only factor that is considered. Gender is not the only factor that is considered. This is an additional factor to take into consideration, all else being equal. The minority candidate or the female candidate, its qualifications being equal to her male counterpart. And in fact, this is something that I'd really love to hear from our viewers on. If you know or have worked with some of these so-called token minorities in your workplace, please send us an email about it. I'd love to hear about it. But I think that it is important to distinguish between what you're discussing, and that is unqualified minorities competing with qualified white people for the same position, versus all things being equal, and that final factor of race or gender being taken into consideration.
Now, Lee, I'm a little bit curious, too, to see what your take is. I know you've spoken a little bit about it, about this Supreme Court case, but have you seen that in your own practice where you are now getting these, quote-unquote, reverse discrimination cases? Because, Ms. Fisher is a white woman, and she's claiming I've been discriminated against because I am a white woman. So have you seen a rise in those types of cases?
Not a rise, but I think that in the eyes of the law, everybody is equal. And by the way, if you are a person, a Caucasian person who lives in a community or works in a community that is mainly of minorities, guess what? You're protected too. So some people refer to it as reverse discrimination. But yes, I've had my fair share of those, and I have no problem in prosecuting those cases. And as far as I'm concerned, we're all equal under the law, and this is one of the arguments that Fisher's attorneys are bringing this case, by the way, to the Supreme Court under the 14th Amendment of equal protection. I've even had lately reverse sexual harassment cases whereby it is the male, that is claiming that he or they have been sexually harassed by a female. And just to regress a little bit as far as your last point, which Adeline had addressed, I think we should allow Grutter to continue at least until the year 2028, as predicted by Justice Sandra O'Connor. I think the analogy of the female population who have benefited by getting and being able to claim the affirmative action or the protected classification of females. I mean, look at this panel here. We have 3 attorney-trained individuals, and 2 of them are females. So I think if we allow the Grutter case to continue and continue to be the law of the land and revisit this perhaps in 15 years from now, I may change my mind as far as affirmative action is concerned.
Well, I appreciate your position, Lee. I think that, again, I understand what you're saying, but I still believe that we need to provide opportunities for disadvantaged children. I think there are so many that are out there, regardless of color. The poverty is rising in this country, and there are so many kids in Tennessee and Mississippi who don't fit, certain criteria, and who may not get the opportunity to get a higher education because they don't fall into certain classes or certain groups of people. So, I mean, that's really just my point, I think that's really all the time we have for affirmative action today, but we do also want to get into a lightning round debate, and that is on physician liability. In particular, I think you guys have noticed that over the past couple of years, there have been so many celebrities who have died due to overdoses of prescription medicine. There was Anna Nicole Smith, there was Michael Jackson, Heath Ledger, and most recently, Whitney Houston. So people are now sort of saying that doctors should be prosecuted. There's a big movement to have doctors prosecuted whenever they prescribe medication to people, and those people end up overdosing on those meds. Adeline, what do you think?
Well, I don't know that all of these celebrity deaths were the result solely of prescription drugs, and I suspect that there are a number of factors that contributed to their deaths, the prescription drugs being one of them. However, if I think even one person dies as a result of some doctor's negligence or recklessness in prescribing a medicine or overprescribing a medication to someone, and that medication causes that person's death, absolutely they should be prosecuted. It is the doctor's responsibility to monitor their patients, to investigate what other medications they may be taking, to consider the interaction between those medications, to consider whether or not there's a possibility of death, to discuss the risks of the medications with their patients. So the doctor is really in the front line of protecting this patient. And I think that too many doctors, for their own convenience, will write a prescription and then make it for, you know, a dozen refills and really not touch base with that patient again and not see that patient again until a year later. And that being the case, there's plenty of opportunity for a number of things to go wrong with that patient. So yes, if something that a doctor does results in someone's death, that doctor should be held liable for his actions.
Well, you won't be surprised to hear that I disagree with you.
Oh, no, I'm not surprised.
I think people should bear personal responsibility for themselves. If it's a child, obviously the doctor should be prosecuted, but if you have a grown-up, you know, like a lot of these celebrities who it comes out in hindsight where doctor shopping, have gone to 3 or 4 different doctors to get their prescription of Vicodin and Xanax, and now they're overdosed because of, you know, of taking multiple prescriptions, then so be it. If they die, it's their personal responsibility. And at some point you have to say, okay, we're going to let this go and let them deal with it. I just don't think that doctors should take the risk of losing their license now because some grown person decided they were going to take more medication than they were allotted. What do you think, Lee?
Well, actually, this is on this topic or this issue, I probably would be inclined to take the middle ground. Mm-hmm. I think the operative word here, as far as the prosecution aspect of it, the criminal prosecution aspect of it, is if they overprescribe. I think if they overprescribe and they know that they are overprescribing, after all, like us lawyers, they went to medical school, they've been practicing, then they should be prosecuted. However, on the other hand, if they do not overprescribe, I think the civil, such as med-mal, should really be enough to deter them and take care of that. And that's another reason I don't think the tort system in our country should be reformed.
Well, that's a talk for another show, I guess. Well, that is all the time that we have for today, and I hope all of you out there have enjoyed our discussions on affirmative action and our brief lightning round on physician liability. Join us next time, please, when we are going to be discussing whether prostitution should be legalized. Adeline?
Well, that's going to be a very fun discussion, so please do tune in. Visit our website, the talk show, the Opinion Talk Show, theopiniontalkshow.com, and send us your thoughts. After all, the show is about your opinions, and we want to hear from you. So please send us your ideas. We'd love to hear from you. Maybe we'll be discussing something that you recommend or you suggest. At the website, you'll find our email addresses, so we look forward to hearing from you.
Thank you, everyone, and thank you for watching.